The law is right that for there to be a valid agreement or valid contract, some elements or ingredients must be present. One of such is that there must be a valid offer. Hi everyone, my name is Yusuf Oluwafemi Salako, popularly known as Ori David, a 500 level student of law, University of Lagos, a founder of the Ori David Consult. And today we shall be enunciating on a very important topic: invitation to treat. However, before I proceed to delve into the heart of the matter, if you're new here, I say welcome to you. And please do not forget to click on the subscribe button so you get notified whenever we upload videos. Now, so the subject matter: an invitation to treat. What is an invitation to treat? An invitation to treat is simply not an offer. It is an invitation to come make an offer. An invitation to treat is not as definite or final as an offer. In fact, an invitation to treat is a pre-contractual representation. That is, it is an offer for the other party to come negotiate, to come make an offer. And you would hear what Bowen LJ said in the case of Carlill versus Carbolic smoke ball, when he said, in invitation to treat, it is you, the offerer, that you offer to negotiate, or you issue advertisements that you have got a stock of books to sell or houses to let, in which case there is no offer to be bound by any contract. Such adverts are offers to negotiate, offers to receive offers, and offers to chaffer. What is important and significant for us now is that we must understand that an invitation to treat is not capable of being accepted. An offer is capable of being accepted, and that is why an offer can ripen into a valid agreement. The offeree cannot purport to accept an invitation to treat. In an invitation to treat, it is you that you are making the representations, that is the invitation to treat. You are not the offerer. You are in actual fact the offeree, because what you are doing with that invitation to treat is that you are calling on all the interested individuals or parties to come make an offer. So it is an offer to come make an offer. It is a pre-contractual relationship. These are the things that you do before you actually get to make a contract, before there can be a valid agreement. So if you walk pass through Tejuosho Market, you see several bookshops, you see several stores, and as you're walking by, what they are doing by basically displaying those goods is not that they are making an offer, but rather they are calling on interested individuals to walk down into the stores and make the offers. So you will hear and then you will see how the court in the case of Belliet versus Francis had also been able to enunciate the principle of law governing an invitation to treat. But what is important is that you must understand that there is a dividing line between an invitation to treat and an offer. And an offer is not an invitation to treat, because an offer must be clear, precise, and final. But in an invitation to treat, they are preliminaries. You are still walking down to making the offer and for the offer to be accepted. Now, there are several situations and circumstances in which an offer or an invitation to treat rather may be implied. One of such is an auction. In an auction, the law is right that the auctioneer's request for bid is not an offer but an invitation to treat. Instead, it is the bids made by the bidders that constitute the offer. So it is the bidders that are the offerers, while the auctioneer is the offeree. That is the reason why the auctioneer can decide to accept a particular bid and not accept a particular the other bid. Although you must understand that when there is no reserve price, then he has to accept the bids of the highest bidder. And you can see what the court was saying in the case of Payne versus Cave, that the bid itself is the offer, and acceptance occurs when the auctioneer's hammer falls. This was the court in Payne and Cave. Also, you must understand that an advertisement that an auction will take place at a particular point or at a particular place is not an offer. It is simply an invitation to treat. So if that auction does not take place, then there is no liability. And it is also important to understand that the court in the case of Payne and Cave relied on section 57 subsection 2 of the Sales of Goods Act, and then to say that when bids are made, offers are being made, and higher bids then automatically exhaust the lower bids, and that is that for an auction. Now we must also go to another circumstance or situation in which an invitation to treat may be implied, and that is where there is a display of goods in shelves in a shop or supermarket or self-service shops. So what this means is this, that if you should walk into, let's say, ShopRite, the goods are displayed, yes, with price tags, but the fact that they are price tags does not mean that they are offers, because when they are offers, it means the moment you pick any item and you drop the item into the carrier basket, automatically you have accepted. So which means that the clerk or the company through the clerk will not be able to say they are not selling to you. Why? Because if they should do that, it will amount to a breach. Remember that once there is acceptance, anything that you do that is contrary to the terms of the contract amounts to a breach, and that will not make sense, so to say. And that is the reason why when you get to the counter and you meet the clerk, you can see that if let's say you had insufficient fund with you, what do? You can pick out of the item, drop some. The reason you can do so is because by that time you are still the one making the offers. Display of goods are necessarily an invitation to treat, an invitation for you to come make an offer. And a leading case in this particular respect is the case of Pharmaceutical Society of Great Britain versus Goods Cash Chemist, and we all understand, or we are all aware of what happened in that particular case. It was about buying a particular drug that had poison in it, and the law was that it must be with the recommendation of a chemist. Now the particular pharmaceutical store had its own resident chemist, but it was not available at that particular moment. So you found out that the plaintiff yes picked the particular drug and was claiming that it amounts to there is a valid agreement between, and the court said no, that goods around stores that are displayed are not offers. They are basically for you to come make the offer, and that by picking it, the plaintiff was practically making the offer, which can either be accepted or not by the respondent. And you can also see the case of Laskey versus economy grocery stores. In Laskey and economy grocery stores, so they were picking a bottle that was labeled tonic, and then it exploded while the plaintiff was placing it in the carrier basket. It exploded and then it severely injured her. So she brought an action for breach of implied warranty of merchantability under the sales of goods. But then the court said that there was even no valid agreement yet. There was no agreement yet, that what existed was simply an offer that had not been accepted. Yes, because by picking it, she was simply making the offer, because solely by displaying the goods does not constitute an offer. It is an invitation to trade. The same thing was also decided in the case of Fisher versus Bell. But it must be pointed out that when you talk about displaying goods, if you look at what happened in the case of Chapelton versus Baring Oba District Council, I repeat, Chapelton versus Barring UDC, you will realize that it's not in all circumstances that you can say that a display of goods does not necessarily constitute an offer and is always an invitation to treat, because the court, it is fact specific. The court has to decide it based on the facts of each case. In this particular case of Chapelton and Barring UDC, the court said that by displaying the deck chairs with a particular notice that, okay, if you should sit on this deck chair, you are going to pay $2, that in itself constitutes an offer, that it had all the elements of an offer. It is precise. So the moment anyone picks the deck chair, that particular person has accepted the offer. So which tells you that it is not in all circumstances that a display of goods will not constitute an offer. It is fact specific. And some have argued that perhaps if the deck chairs had been locked or with padlock, or it had been fastened to something that would make it impossible for anyone to just pick it, perhaps it would amount to an invitation to treat, because by then you have to then speak to the owners and then negotiate, and that means by that time what they have kept out is simply an invitation for you to come make an offer. But in this circumstance it is different. The moment you can always pick it, and then you already have the notice that says that the moment you pick it you're paying $2. So which means they were making the offer, the terms were precise and they were unequivocal, and it had all the elements of an offer. Now the next circumstance is advertisement of goods in a catalog, and it is advertisement for goods in a catalog. So when you issue advertisement, you realize that it does not constitute an offer. It is an invitation to treat. So, and there are times that the advertisement of goods will also be in a catalog. But you will hear what Lord Parker was saying in the case of Partridge versus Crittenden. Partridge versus Crittenden, when Lord Parker said that it did not make business sense for adverts to be offers, as the persons making the advertisements may find himself in a situation where he will be contractually obliged to sell more goods than he actually owned. So which means by the time you issue an advert, you understand, an advert is something that can go wide. So the moment you issue an advert, if it constitutes an offer, then everybody can accept, and the moment everybody accept, you cannot basically conceive of the number of people that can accept, and at the end of the day the law might be asking you to do that which you cannot do, in the sense that you might actually be entering into a contractual agreement to sell goods that you actually own, because the number of people that have basically accepted the offer, the supposedly offer through the advert, are more than the goods that you want to sell, and it said does not make business sense. So advertisement is not necessarily an offer, it is an invitation to treat. But we must also drop a caveat to this, that in unilateral contract like that of the case of Carlill and Carbolic smoke ball, advertisement will constitute an offer. So when there is a unilateral contract, advertisement constitutes an offer, because why? Acceptance in that particular regard can only be communicated through performance. So it is only the class of individual that has performed that particular obligation or met the conditions in the advert that can be said to have accepted the advertisement. So now we also so in unilateral contract, advertisement may constitute an offer. Advertisement of goods in a catalog also constitutes an offer. So when you have a catalog, you have advert there. So supposing you walk down to, let's say, Ozone cinema, and you want to you go there, you went there rather to see a movie. Now you, by dropping the catalog for you to pick your desired movie, does not automatically constitute an offer. That is an invitation to treat. The adverts that you see in the catalog is for you to then make an offer, and you make an offer by saying, I want this particular, I want to see this movie, and then the clerk will then attend to you, tell you the amount, you pay, then process it, and not so by the time you're paying that is when you are the one making the offer that they can either accept or not accept. So we can see that advertisement also of goods in the catalog does not constitute an offer. Now, invitation to tender is also another circumstance. So in an invitation to tender, the law is also clear that an invitation to tender is merely an invitation for you to come make offer from interested parties, and itself is not an offer. So the highest bidder or the highest bids may simply be rejected with no legal consequences in an invitation to tender, and you will hear the courts enunciating this in the case of Spencer versus Harding. But we must also bring to your attention the distinction that was re-echoed in the case of Avella versus Royal Trust of Canada. And what the court was saying in Avella versus Royal Trust of Canada was that the court said that it is important to state that an invitation for tenders may also constitute an offer once there is a clear intention to accept the highest tender. So which means that it is also fact specific. The court needs to look at the text of that for tender, that is the invitation to tender. If you make it clear that your intention is that once there is that you are interested or you are willing to accept the highest bidder, then that constitutes an offer, because it is not an invitation for them to come make offers or to come negotiate. You have stated it's a matter of trying to be the highest bidder. And in this circumstance also, but generally an invitation to tender is not an offer, it is an invitation to treat. Now another circumstance relates to buses, taxis and trains. Now the question is, when you stand at a car park, are you making an offer in such a way that the moment the cab arrives, then the cab man is accepting your offer? Or simply by standing, is it an invitation to treat that you make the offer by attempting to move into the car, and the moment you get into the cab, once the driver starts, once the car is in transit, then automatically the driver has accepted. So issue has actually arising on this, and we hear the court in the case of Wilkie versus London Passenger Transport Board, although an obiter, saying that by issuing advertisements that a bus company was making offers for intending passengers. So if you go to Oingbo bus stop and the conductor keeps screaming Oingbo wow, or keeps telling us, okay, you are going to Bariga, what we're saying is that he's issuing an advert. So if you go by the obiter in Wiki versus London Passenger and Transport, it then means that by saying all this, enter with your change, 100 naira Oingbo and all, he was making an offer that you, the intending passengers, then get to accept the moment you enter into the bus. But the learned Sikh, Professor Itse Sage, had actually argued that the question should be as to when can it be said that it will be practically, it will be legally impossible for either of the parties to then resile out of the agreement, because by that particular circumstance there would have been an acceptance, and after acceptance you cannot do anything contrary lest you'll be liable for breach of contract. So he said that okay, that should most likely be when they are in transit, at the point where either the conductor, either the passenger or the driver, the bus company cannot actually resile out of the particular agreement. But generally you find that there is an invitation to treat also when it comes to buses, taxis and trains. And now the court is also clear in the case of Harvey versus Farcey, and the court said that statement of price is usually simply an invitation to trade. So all in all, what you should take home from this lecture is that you must be able to determine what constitutes an invitation to trade. You must ask yourself whether this particular term or this particular thing is simply a precise term, or it is simply inviting you to come and make an offer. If it is inviting you to come negotiate, then it does not amount to an offer, but simply it is an invitation to trade. So to the viewers that have listened to this video lecture, I also have an assignment for you, and I enjoin you to try and attempt this. And what do you have to do? You just provide your own legal analysis in the comments section. So this is it. You use the ATM, and now when you want to use the ATM, you walk to the machine and then you insert your card. Then it brings some set of instructions that you must follow. First is for you to input your PIN. When you input your PIN, it asks you what transaction you want to do. So let's say you want to withdraw. Click on withdrawal. How much do you want to? It asks you what type of account do you have. You say savings. How much do you want to withdraw? And you click on the amount you want to withdraw. Ask
my journey through the world, over land and over sea, I see different cultures and different people's ways. I was born where the sun never sets and never rises. I was born where the heat is like a second skin.
Constitutes the offer that you accept it. Because when you accept it, that offer, that you got your money. If you have not accepted, then there is no way you can get payment. So the question is, I want you to be able to identify with the legal analysis.
Children crying on the streets, automobiles are making noise, the land is growing dry and weak, spirits dying low. Before fathers are calling me a never tired, never weakened, the pride in me is bursting loose, men are freaking
once again, that is that for today's lecture on the law of contracts. I remain Yusuf as an actor, popularly known as Ori David, and I say to you once again, welcome to my channel. If you are new here, do ensure that you click on this subscribe.
On the farm, my father called me down behind a tree. He said, prostrate at my feet and say,